Oh, man. Great time to get a cold, huh?
Oh my God.
Well, it's allergy season at home.
Terrible.
Yeah. All right, well, I better get back to the webcast, but so you're going to sit right here?
Huh?
Are you going to sit right here?
No, I'm going to sit over here.
So at the end, do you come up and thank them? Is that part of the job?
I don't know.
Would you?
Sure.
And remind people that to get CPE or CLE, they have to sign in at that table at the door.
Okay.
Yeah,
All right,
that's
so
it.
do you want to get started?
And do we have?
Pass a little bit to pass.
Were we 9:35 we were supposed
Yep.
to do? Maybe ask everybody to move
Okay.
up. Actually, just ask them in your welcome. And then
What's that?
ask them to move up.
Okay.
Tracy and Joy want to move up.
Hello, we're going to get started on this session today. If some of you could move up, I understand I'm kind of a back of the room guy too, but if you could, it's a big room, and if some of you could move up, that would be appreciated. But I'm going to introduce two people that are doing today's presentation. One is Joy Feinberg, who's with Boyle, Feinberg, Sharma. She formed a private practice exclusively focused on family law in 1980. She's been an expert and sought-after speaker and writer for 3 decades, and includes her deep understanding of topics such as taxation, BV, pension, spousal maintenance, and parenting. She's known by her clients and peers as a tenacious, direct, and trustworthy attorney advocate, both in and out of the courtroom. She served as president of the USA chapter of the International Academy of Family Lawyers from 2014 to 16, and she is most proud of her presidency of the AAML Foundation. Next up is Tracy Katz, is a partner with Gershey Schneider LLP, where she specializes in forensic accounting. Her expertise covers litigation support services, business appraisals, gross cash flows for support, spending evaluations, pension plan allocation, et al. She is a member of the Family Law section of the Beverly Hills and California State Bar Associations, as well as a liaison member of the Executive Committee of the Family Law section of the Los Angeles County Bar. She is past chair of the Family Law section of the California Society of CPAs and a charter member of the AIML Foundation's Forensic and Business Valuation Division, and she has authored and co-authored articles and lectured on various forensic topics. Please give a hand for Joy and Tracy.
And he didn't say that Tracy has the most fabulous shoes, but he should have, so.
And what he also didn't say is that Tracy has the bubonic plague. But I promise not to give it to anybody if you move up. It's really hard to be in a room this size and feel like you got to get all the way to the people in the back. But
Especially when you have the bubonic plague.
right, I know, it's hard. I will try to do this though, but if you hear me crunching, it's because I'm sucking on a lozenge and trying not to lose my voice at the same time and not cough on everybody. So apologies.
And not die by killing herself.
Right, or that. I should pay attention.
How do we become divorce superstars, Tracy?
Oh, well, I think you should start by learning how to work the equipment would be the first, the first way. Hold on one moment. I think this was supposed to go forward and back. I might have already messed this up, but because I don't. Green.
Green button. Oh.
Oh, there we go. All right, how to be a divorce superstar. We're right there. Okay, so I was right at the beginning anyway. Excuse me. So we're starting with what I always say is the very beginning, the preliminary case assessment. Who are we dealing with? And
This is really important. How many of you are CPAs, as if I could see you with this light? Okay. So there are 2 different types of attorneys that you're going to be dealing with. And I've learned over time that we're changing a bit about that. But there are the English majors, poli-sci majors, psychology majors. You know, I was a English history major. So, you know, we don't have the background that all of you folks do. And you have to cater to us in a different way than you do. Is Jeff Brand in the room? Jeff Brand probably doesn't even use anybody else because he is a CPA and he is a business valuation person. But there are a lot of attorneys today who do have econ degrees, financial backgrounds, and other things that set them apart from what I would call what was the main bulk of the divorce bar when I started some years ago. And that was people like me. So assess who we are and ask from us, okay, what joy do you want from me? I know today a whole lot more than I knew when I first started, but your role in dealing with someone like me is to set the table for me, make sure that we both are on the same wavelength about what we're doing in the valuation, find out if we're only doing a valuation or if your role is to find out whether or not there's income, whether or not you're going to be doing dissipation, whether or not you're tracing, and of course that's her area of expertise, but you know, are we tracing to find out whether an asset is marital or non-marital? So there are a whole multitude of tasks that you may be asked to do. Be clear with the lawyer, for the lawyer to be clear with you about what your role is and define that to protect yourself.
And I would say there was a time in my career, just like Joyce said many years ago, where I would get a phone call from an attorney who I didn't know, and they would say, oh, I got your name from so-and-so, or I saw you speak at one of these conferences, and that would excite me, you know, a new source of business, and that was exciting to me. Now I get a call from an attorney I don't know, and I just get this dread in my stomach because I don't know what that means, and I really have to ask a lot of questions, you know, because nothing is more scary than when you, the CPAs, all the people who raise their hand, end up becoming the quarterback of the team because you're working with an inexperienced attorney. That is scary and that is very frustrating. And so before I take that case with the new attorney who says, oh, I saw you speak at that National Divorce Conference and you were terrific and I got this case and I think you'd be great for it, I really ask a lot more questions. I don't just say, oh, that's great, here's an engagement letter. You know, I get a little background about the attorney, I find out, you know, more about the case, you know, I look immediately, get on their website, you know, is their bar number if you're in California 300 and something thousand, you know, I do a little bit more research.
Tracy, don't you ask your colleagues?
Oh, that's the next thing I do is I hang up the phone and I start talking to people because, by the way, again, your colleagues know everybody. And if you start making phone calls and nobody's ever heard of this person, boy, does that tell you something. So,
or they've heard of you and they know that you never pay your experts. I mean, we have a few of those in Chicago. I'm sure they don't exist anywhere else.
Never. So. No, not in California. Unheard of. Absolutely unheard of. So again, I mean, that is, from my perception, nothing is more daunting to me than feeling like I'm the person who has the most legal knowledge on that team. It really shouldn't be. So.
Well, I'm sorry that you feel that way, because sometimes it does happen, and it can end up being very good relationships. I can tell you that there is a person who's an expert in Illinois who did a lot to train me when I was a younger lawyer learning this, and it developed into, I think, a really good relationship and helped me learn. So be kind to us, Tracy.
Yeah. Valid point, very valid point. Well taken. All right, discussing strategy with the client.
So confidentiality agreements. When do you suggest that one's necessary? What do you think about when I, as a lawyer, say, Tracy, I have this client who's developed this business that's so new, and I want you to sign a confidentiality agreement?
Quite frankly, I sign them a lot in LA, and truthfully, if the attorneys are signing them, I'm signing them with the attorneys. I'm part of the team. And usually it happens because there's some proprietary something with the business. It's a family of note in LA. They care about keeping things confidential. And I'm gonna say this out loud. Oh, we're being webcast. I probably shouldn't say this. 9 times out of 10, I don't read it all that thoroughly because the attorneys have read them and prepared them. But the things that I really look for in the confidentiality agreement that affect me are, what are my obligations in terms of what do I have to do at the end of the case? Because that's all that I care about, is what are my burdens. Sometimes they can be a little onerous. You have to give back every piece of paper you ever put your eyes on, and you have to give back, every single thing you ever looked at, and every person you ever spoke to and mentioned this person's name to, you have to fire. They can be a little burdensome. So that's really the only provision that I care about in the confidentiality agreements, is what are my obligations under them when the case ends. Because if there's a purging of everything, I want to know how I have to satisfy that. That's all I really care about.
I am a tad diabolical. So let me tell you, CPAs, a reason that you should want confidentiality agreements. What do you think lawyers do with copies of your old reports? Come on, it's not hard. We go through them.
Oh, sure.
If we find a line that challenges anything you
sure.
say in the current report. I'm sorry.
Dave, I have had my old reports handed to me on cross-examination and a later date at a later case. It's fair game, right?
Okay, so you have a confidentiality agreement by a court order, because they do them as court orders in LA, correct? Is there
Yes.
any place they don't do these confidentiality agreements as court orders? All right, no hands went up. I'm going with no place. Okay, will not do a court order. And what does that mean for you? Protection. You're not going to have your prior report shoved in your face. And I can tell you, young associates love going through your report. So if your attorney does not suggest to you that there be a confidentiality agreement so that there's nothing that can be reported by you out in the future, you make the recommendation, you look like the hero, you're doing something for you as well. And I think the clients will be very happy, because I represent a lot of business owners. Chicago's an entrepreneurial town, and they are so happy when I think of it, or I say it to them, or I get it out before they say it. So they go, oh, she's really on top of it. So lawyers, CPAs, you both learned something. What about filing first, Tracy?
Before we do that, I just want to
sorry.
say one more. I say this as a practice pointer for the CPAs out there. We've learned this the hard way. You also want to be really careful, have some way in your office, which we now do in our office, of denoting which clients have confidential data in them. Because when you're being deposed and attorney says to you, and how many times have you taken a position where you've testified about, in California, it may be about a Pereira issue. It's a case for evaluation, stands for evaluation type of methodology in separate property, dealing with separate property. And you start rattling off cases. You need to be very careful if perhaps you shouldn't have mentioned a certain case name because it was confidential and you're not necessarily thinking about that. We've had that issue before. So I thank you. I say that as a practice pointer because it's happened. It's something to think about.
So as lawyers, we always think about, do we want to file first? There's a theory of primacy. Is there any reason, Tracy, that as a CPA or somebody who's doing valuation or tracing or anything that you do, that it matters to you one way or the other as to who files first?
The only time this ever comes up for a discussion in my jurisdiction ever is with, let's just say it, with Hollywood type cases where there's publicity issues and people care what it looks like and how it's going to look in the press. That's the only reason that ever comes up in my jurisdiction anyway.
Okay, so trial subpoenas and deposition subpoenas.
No, whoops,
What?
sorry.
You,
I jumped ahead, go ahead.
anywhere you want to go, I'll follow. All right. So I think it's important when you're sitting down to talk with you folks about what's going to happen to your office when you get these subpoenas. Sometimes lawyers issue subpoenas before you've even completed your report. Why would you do that? Well, I have a case right now where I know the other side. It's a real estate enterprise business where there are 14 different entities. 8 are buildings that have anywhere between 1 and 25 tenants, different leases, different things going on. And these people were really wise. They bought 22 to 15 years ago in an area of Chicago that you could have been killed at in broad daylight. But they bought their property there. It is close to the downtown area. So what do you think their property's like today? Fabulous. It is a hot area. It is a smart area. And the real estate has only gone up. One of the buildings they own is in an area where we used to have a courthouse. When I went to this courthouse, which was about 1.5 miles from downtown, and my husband's in the room, but I never told him this. I would, at the end of my day of trial, I would stand in the middle of Michigan Avenue on the south, it was 1300 South. I would rather have been killed by a car hitting me than to have waited on the sidewalk for what could have gotten me. Okay, the piece of property that they own there now, our appraiser had it really high. So as you can see, since the other side is saying to me, Joy, let's go to mediation. I said, okay, show me your report. Well, no, we have our positions. I went, okay, so I issued a subpoena. So now I'm going to get their values on the real estate, and certainly what's coming is they're going to issue a subpoena to my guys and have full appraisals, which they don't have, but that's the way we did it. So you're going to get subpoenas at various times throughout the case. You might get it for a piece of information like that. I want to get this proper. I want to find out what's going on midway through because I don't have an attorney who exactly understands what is going on. I want to know what they've looked at. Okay? What have they seen, especially in a tracing issue? Okay? Because if you're tracing assets that are flowing from one entity to another, as you would imagine happens in real estate or other things, you want to know how far back these records go. So when your attorney is talking with you and suggesting tracing, you might want to say, I want to go all the way back. Now, what has the other side done on this case? I know that there's some states that don't have discovery, but most of us do. What's the standard amount of time that you ask for business records? 5 years?
5 years.
5 years.
Maybe real estate longer, maybe.
Yeah. Okay. Well, these properties have been held on to for 20 years. But the other attorney has not sat down and thought this through. So by not doing that, I have a standard discovery, 5 years. They're not going to be able to trace anything. Their expert's not going to know what they're saying. Their expert's going to say, no, I didn't have records going backwards. Nobody's asked for the records from the beginning. My people have them. So you can understand why you need to actually think through at the beginning of your case what it is that's necessary and how you modify standard requests.
And I would just say a little practice pointer. Depending on how contentious your case is, at least, and again, and I know I'm speaking from a California perspective, and I don't know how it is. Every jurisdiction may be different. But at least in California, once you've written a declaration, you've essentially issued some opinion. You can now, you're fair game to be deposed or to have your file subpoenaed, right? Now I've been designated as an expert, so to speak. So now the subpoenas are coming fast and furious from the other side. However, and here's the caveat that I would say, this is one of those depends on how contentious it is and depending on the relationship you have with your attorney that you're working with. Sometimes attorneys never issue overly broad subpoenas, right? I mean, never. But sometimes it's worth paying attention because you the expert, might have just done a declaration on the issue of cash flow. That's the first thing that's happened in the case. And the opposing attorneys have issued subpoenas for, everything so far. And the attorney you're working with, you can sit down with them and say, hey, wait a second, I have only issued this one opinion about this one thing. Perhaps we should move to quash the subpoena on all these other issues because I really have not given any opinions about the business valuation thus far. I haven't given any opinions about the tracing. Yeah, I'm working on it. We all know I'm working on it, but I'm not designated as an expert yet. And we've had those battles. And by the way, again, they are winnable. So something to think about. You don't necessarily have to respond to every single subpoena if they are not necessarily timely. But again, it's a discussion and it is a costly battle to fight. Don't always win, and who knows if there really is something that you don't really need to produce at this time anyway. Again, that's a strategy.
I can see that we have a question over here, so whoever has the mic, if they could go over there. But while we're doing that, I want to say one thing to you, to everyone. Do you all know what a telephone is? Okay. If you're an expert.
That's the thing you text on, right?
Yeah.
Okay, just
check
it.
If you're
for the millennials out there.
You don't want to have emails with people that are discoverable. And you lawyers, we have to remember that anything we put down is going to be seen at some point in time. Unless you live, does Pennsylvania have discovery, or have they started that yet, or have they not? But unless you're in a jurisdiction that doesn't have discovery, for God's sakes, talk to your experts by phone. I send a text saying, or I send an email saying, when can we talk by phone? It's a code. I don't want to put it in writing. If you take nothing else away from this program, that is a priceless remembrance. Because I know you all know it. And I know how busy we get. And I know how easy it is, especially me. I type 120 words a minute. But you really have to use the phone. And I have to remind myself to do that too. Do we get the question?
Yes, can you hear me? I guess you can.
Yeah.
Going back to an earlier issue with respect to who files first.
Yes.
In some cases, it's very critical because it isn't just necessarily California. I've had cases where, for example, the critical issue is who files first because it is a function of what state the case will be heard in. I had a major case where the parties lived in Texas, and they also had a home in Los Angeles. And our client wanted to file in LA for obvious reasons, basically support. But the husband filed earlier in the state of Texas. And then the court ruling came down. The court ruled that Texas had priority because he filed first there. And that had a huge impact on the case.
Might get a little less money in Texas than California,
Yeah, virtually
right?
zero.
Just a little.
Okay. So, yes, surely
Jurisdiction.
that's an important issue on who files first. Also, who files, or the timing of filing, in many states now sets the date upon a value. Some states say at the time of the divorce, some states say at the time of filing, and it shortens up maintenance. It does a whole lot of things. But for our purposes here today, and thank you for the point because it is very important, we're talking about working with your expert on valuation, so, or any of the myriad of things that we work on. So did we finish that last slide?
We did.
Okay,
I
we
think
killed
did.
it.
Yeah. So this one is one that is very near and dear to my heart about being cognizant of your audience. I always sort of prided myself on being able to read the room, if you will. And I just fairly recently, a few years ago, I had the operating spouse husband, and he was running this hedge fund, young guy, Ivy League educated, you know, we're talking Yale, undergrad, Harvard, master's degree, 15, $16 million in the bank before he was like 35. I mean, we're talking this guy was a business guy. And I really just sat down with him and I talked to him about how this divorce was going to work. This is just a business transaction and this is what happens in California and this is how we do it. And I was, you know, I got this. This guy and I, we're going to speak the same language. We got this. And within 5 minutes, the tears started flowing. And he literally just looked at me and he said, "You just reduced my marriage to a financial transaction." And I thought, oh my God, I did. Because I literally just thought that that's how he was going to get this, right? He was a business guy and I just dismissed him as I would be able to put all of this in numbers that he would understand, and I would, you know, put a nice little red ribbon around this and make it easy for him. And he was all of those things and he got all the numbers, but I had completely discounted the fact that this was also still, you know, the most emotional thing he was going to do in his life thus far at 37 years old. So it is very important to be cognizant of who you are talking to and also to maybe be a little bit more empathetic. I think I was more empathetic maybe earlier on in my career than I am now.
And being older and looking over my practice and trying to stay fresh, one of the things that I keep trying to tell myself, I know Jim at the end of the last speech talked about how many things he was going to take home from this, and I think these programs never fail to remind me about how emotional the work we do is, no matter what we do with dollar signs and no matter how we understand where this case is going. We're dealing with human beings with all of their frailties and all of their insecurities and all of their being scared, and you know, it's just something that when you start forgetting that, you need to have it brought back to you, because it is so important, and we need to have that humanity with our clients that makes them feel like they're understood, because you can be the greatest lawyer in the world, but if you don't have clients, it's not going to help you. So, okay, is it easier working with a spouse who has the understanding of what the business is?
I would always say yes. I will always say yes. Even in that instance where, again, this lovely man who I terrorized without meaning to, completely unintentionally, it was still always so much easier for me to talk numbers and sense with somebody. I mean, I always say to my clients, I don't do kids. You know, as soon as they start talking custody and as soon as the emotional stuff comes out, I zone out. That is not my bailiwick. It is not where I live. So, you know, I always find it easier to live in that world. And I mean, maybe I'm sexist. I sometimes find that if I have the non-operating spouse, and I'll just assume it's the wife for a few moments, it's sometimes harder for me to relate, especially if they're not the ones who chose this path. If they are wronged, I have a
If
really...
they've been dumped.
If they've been dumped, thank you. I was trying to be nicer, but if they've been dumped, I have a really hard time with all of the emotional baggage that comes along with the being dumped. I am much less empathetic than I probably should be, and I have a harder time being that person that you just instructed us all to remember to be. And I wish I was better at it.
Well, there's one thing that I always think about. You know, there are businesses where two people are involved. And I'm always concerned with the spouse who has a lot of information about the business. And I want to work with the expert for ideas on how to protect it. Let's talk about family businesses. Okay? So these are the worst wars that you have ever seen. And when you have children and a parent move together to try and take over a business, how many of us have had those cases? Use divorce court to essentially try and take over the business and kick out one of them. Well, if you haven't had this pleasure, you're not going to miss it. Believe me, there are plenty out there. Or there are the King Lear stories. Yes, Joy, I gave 20% to each of my 5 children, but you have no ownership interest left. Oh, well, but I run the business. I go, well, they might come back and bite you. You know, when you see something and it happens, they wonder about you. So in those cases where you have somebody who's intricately involved, I want to make sure that we take all the steps that can be taken to protect their business. How do we lock down the customer list and protect it? How do we stop one of the parties from going out and trying to take business away? How do we keep our eyes open for children trying to set up their own shop in the same industry? You know, I'm not sure I always have the answers on this, and I will look to the CPAs to provide guidance, but it's one of those things you need to think about as you're going through these types of cases. So,
Okay, let's move on to discovery. Something that's sort of near and dear to my heart, because I find that at least in the area that I live, we, the forensic accountants, tend to be the document repository for the attorneys. We tend to really handle the discovery. So, you know, the attorneys they propound all the discovery, it comes in, and they just say, here, have at it. And we file it all away digitally, and we give them our beautiful document reconciliation and say, this is everything that you requested, this is everything that was produced, and this is what's still outstanding. Then you go on your merry way and you say, this is what you failed to produce, and you have your meet and confers, and then you have your motions to compel, and you know, on and on and on and so forth, and we are still the document repository. So discovery near and dear to my heart, because we end up being the document management system. Having said that, we ended up in this business, and truthfully, all we, the accountants, ever care about are the tax returns, the financial statements, the general ledgers, deeds for real estate. You know, there's a whole lot of documents that you, the attorneys, request. I don't ever care about. I don't want somebody's passport. For whatever reason, you guys always request that. You know, health insurance. I mean, there are so many documents that get requested as part of standard discovery requests that, you know, there's always this conflict that we're managing. Again, if you're doing that as part of your discovery, as the forensics that we never care about seeing.
no, that doesn't happen in my office, and I'm sure when I look at it, the Academy Fellows sitting out here, I'm pretty positive that you keep track of what discovery that you have and don't wait for the CPA to say you're still missing these things. So we do the bait stamping, you know, and by category, by items, so that we're pretty thorough and can find out what's where, and we have an overall summary sheet where we can actually say it's this document number the first one and get to the entire series of what, if it's a bank account or anything else. So we know what's there, but we need you to tell us if you need more.
And are you maintaining digitally, documents digitally
Absolutely.
also? Yeah,
Yeah,
I
yeah.
assume most people are doing documents digitally at this point? Yes? Show of hands?
I don't just do it digitally. I'm old. I like the paper. I like tags. I like my little notes. That's how I do it. The younger ones in my office look at me and go, yeah, okay. But we all have our ways of working with these things. As long as it works, it's fine with me. But we do two systems because I like to be able to, because I'll work late at night, I'll work on weekends, and we have this document management system called WorldDocs. If I ever meet the person that did that, I will shoot them, okay? Just do not point that person out to me, but people in my office say they like it. I go to the file, I pull out the checking account. I want to look at it. That's just the way that I do things, so.
You know, we do documents digitally in our office, and it became, this really tells you, gives you insight into the mind of a madman. Because we ended up, the program that we use, we ended up having to get the rights to alter it because there ended up becoming this tug of war. How do you maintain your documents? No, I want to be able to sort by just the document type. So I want to be able to look for tax returns. No, I want to be able to sort by who they belong to, by the entity type. I want to first be able to look for, are they the husband's or the wife's or the business? So, you know, and that was a big fight, and every partner wanted to be able to find their documents differently. So we had to write a program that allowed everybody to sort differently. So now you can sort it by entity, you can sort it by document type. If you're one of the crazy people that only cares about, I want to sort by time period, you can now sort by time period because everybody's mind works differently. We couldn't all agree on a way to store our documents, so.
Okay, Tracy, I'm
crazy
having
people.
you do my documents.
I mean, again, it's just the way, this is what happens when you deal with nerds. We all think differently. And so this is what we do. All right, this is what we were just talking about with the detailed document reconciliation. What did we receive? What date were they received? Who produced them? Meaning, did they come from the opposing spouse? Were they produced via subpoena? Are we bait stamping, et cetera?
So I would like to tell you a war story just to scare you. How many of you live in jurisdictions where courts can sanction you for false statements? Yeah,
Right.
come on, it's
So-
not just Illinois. And for, there are sanctions that can be financial on discovery, failure to produce.
Sure.
So we have just an excellent lawyer in Chicago. He's just great. He's a great trial lawyer, notorious for not giving you documents, notorious for going into court when you have a motion to compel and saying, oh, they didn't give me anything, they didn't give me anything. And he went into one court too far, as we say, and said, I was never given these documents, I was never given these documents. And the other side, and I wasn't involved in this, but it got appealed, so we all read about it. The other side brought in their CPAs, showed what dates they were produced, what the document numbers were, the cover letters that had all of them. The judge fined this law firm $50,000. Yes, it was a big case, that was a drop in the bucket, but it was still $50,000. So it's important for you to keep track of what you're doing and make sure that your experts have what you have, because sometimes there are things in my files that have never gone to my experts. I don't understand this, but what I do is I send the entire chart of what I have and of the things that they want. I don't send the chart, the passports, that's all crap, it's all in another area. So I send them the chart and say, is there anything on my list that you don't have? And that way I make sure that however it fell through the cracks, we've dealt with that. So that's just one of our checklist things. And if you have a better way, tell me how to do it. That's how we do it. Okay.
I would say this is one of my big grievances. I would always say that, you know, your poor planning does not become an emergency on my part because
This is a motto of hers.
I
I'm
just-
sure that the best gift we could give her would be that on a big plaque.
Yes.
Okay.
You know, usually there's a couple of expletives before the word planning, describing how you're planning, but I figured for this audience in the webcast, probably better not to use those expletives. But that happens sometimes, and I will forgive one or two of those when I have relationships with the attorneys and I love them because we all make mistakes. I totally forgot, but we have to get this cash flow done and it's due in 2 days and I just need you to do it. So please, okay, I'll get it done for you.
It says 35 minutes.
I know,
10 minutes.
10 minutes. I'll get it done. I'll get that done once, I'll get it done twice. After that, you know, we're gonna have to have discussions because you probably need to work with somebody who's just as disorganized as you because that's not the way I work. So I really think that that's a serious discussion that the experts and the attorneys have to have when they're working together about planning.
So when Tracy and I first spoke about this, the very first thing that we both talked about was deadlines and timing. Okay? These, you have to calendar. Tracy will not work with you if you do not know what a calendar is and if you do not give her the time to do the work and the clarity with which she can manage to do the work. So think about that because I see too many people waltz into meetings with their experts and not know where they're going. And I say to you as CPAs, if you see that going on, you stop and say, we organize this now, or I can't do this. Because if you have somebody who needs that kind of organization, you can train them to do the right thing. Or you can say, I'm not going to do it. Tracy lives in a world where she can say, I don't need this.
It's not
but
fair to
not
the
all
client.
of us do.
Yeah, it's
so.
not, I mean, what kind of quality product am I turning out? I mean, the client's paying for. It's just not fair. It's not fair to everybody on all counts. And it's not fair to you guys as the attorneys who are then scrambling to ask me questions and how did we do this? And maybe there's something complex that you then have to figure out or no, it's just not right on all counts. So
Okay, so Tracy, you get the assignment done early because that's who you are and
Yes.
that's what your people want. Do you give the written report, the pre-report to the attorney, or do you sit down and talk through things before you finalize
That
the
one.
report? Okay.
ding, 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 that
Ding,
one.
ding, okay.
That
This-
answer.
This is the voice of experience, okay? So, you know, all of your iterations are going to be requested. Remember that. So as you sit down to write the report and outline and think it through, that's when you want to have the meeting. Here's what I'm finding. Here's what I'm seeing. Here's what I think I'm going to be saying. Here's where I'm headed. Am I missing anything?
Yeah.
Okay? That way you can prepare your report without saying, oh yes, I met with Ms. Feinberg for 4.5 hours. What did we talk about? I don't remember. Did you change the report? Oh, significantly. What did you change? Well, I corrected typos. I did. You know, maybe there was a theory or two. You can't have that. So really think about having that meeting in person where you talk about where you're headed to make sure everybody's on the right track. Okay.
Some of the stuff we can go through quickly. I just think of these as practice pointers. I return all my phone calls, emails. You know, even if I'm out of the country and I can't really get to something, I always let people know who they're going to talk to in my absence. There is a manager, there's a staff, there's somebody working on their case if I'm not available. I just think that's good practice. I'm sure most people do that. Yes?
Ditto.
Okay. Assisting counsel with special interrogatories, if they're applicable, if you have them in your jurisdiction. Separate properties, what documents support those contentions. Let's see, I think we can go through some of these a little bit quickly. You know what, this one sort of dovetails into what Joy was just talking about. you know, when you're sitting down and meeting on some theory, there may be multiple scenarios of a valuation that you want to talk through or that you need to be thinking through. Well, you know, the classic one is always, well, there's a lot of cash in this business. Well, let's see, how much cash are we talking about and how does it really impact the valuation?
And do you have to amend tax returns, or do you need to settle the case out of court so the judge doesn't say, I think I have to refer this to the U.S. Attorney's Office? One of the favorite days of my life. Okay. So.
Right, or again, if you have a prenuptial agreement, what happens to this case if the prenup is valid? What happens to this case if the prenup is not valid? So working through all of that with the attorneys, those are typical assignments that you would do together collaboratively.
So the most important thing for you to do is not just assist us with deposition questions, but you have 2 reports, and for whatever reason, 2 excellent, you know, experts come up with 2 completely different values. You know, I want a chart. I want to know what the differences are with as much ease and clarity as I can possibly have, and I want to sit down and talk with you and defend. How do I know how to defend? And do you know what happens at that meeting? I take the notes, okay? I write up the questions. It's my work product, okay? Important, use it.
That really is the first thing we do. I mean, as soon as we get the other experts' business valuation report, as soon as we get their community property balance sheet, as soon as we get their cash flow, that is, every person in my office is trained. That other expert's report comes in the door, you put together a side-by-side, and you give me a bullet point as to what those differences are. That's all I want from you, because either I'm going to be asked to write a declaration about it, or I'm going to be asked to testify about it, or the attorney's going to call and ask me questions about it. That is the first thing you do. Put that side by side together.
I want you to help me with my charts, because you guys are better at charts than I am, because I believe in the KISS principle, and I believe that when you present things to the court in the easiest possible manner and with demonstrative evidence, you will be believed, and it will help your client and it will help your side. And making it simple and having your vision of synthesizing what we're trying to say will help the lawyer each and every time win the case. So.
And again, it doesn't even necessarily have to be a valuation where you've reached a different conclusion. Even just the community property balance sheet. Look, we have different balances on these accounts because I used a statement as of this date and the other side used it as of that date. You just need to understand differences so you're prepared walking in for, even if it's just a meeting.
Well, and the deposition too, because not every case goes to trial. And if you kill somebody at dep, my husband does work, so he deals with a lot of business valuations and ESOPs. And I know a lot of the valuation guys, and I was deposing one of his very close colleagues, and he said, Joy, you're being mean to me. I said, you wrote the report. So you have to know where you're going in order to be able to do the deposition, so maybe the case doesn't go to trial. So I see that we are 0 time right now. We have done the rest of the outlines to give you some help, but we really hope that we have given you the ability to make the CPAs work better with the lawyers and the lawyers work better with the CPAs. Thank you so much.
Thank you.